Do you know what's not very demure and very mindful? Working beyond your project scope without requesting further payment, answering emails and texts from clients 24/7, mixing your personal and business funds in one bank account, pretending like you don't need business insurance, booking clients without a signed contract or with a Frankenstein contract that you piece together online, comparing your life and business to snapshots that you see on social media, copying someone's intellectual property and claiming it as your own. Do you know what is very demure and mindful? Using a legitimate legal contract for every single client, even family and friends. Setting strong boundaries with your clients so they know what to expect from the start. Being on top of your finances with a business bank account, bookkeeper, and business insurance. Spending more time creating than consuming on social media. Actively protecting your intellectual property through trademarks and copyrights. Delegating your work and hiring team members to help you scale your business. And taking time to rest, relax, and recharge so that you can show up as the best version of yourself. Now, speaking of very demure and very mindful, there is a huge trademark issue going on with this phrase that you need to know about. And as your friendly online attorney, I'm here to spill the details on all the legal drama and how you as a small business owner can learn from this situation. So let's get into it. Hey there, I'm Paige Griffith, your host and an attorney for small business owners. I help online businesses and creatives get legally legit in no time. This podcast is all about the legal and the Paige behind it. I'll break down and simplify legal talk while providing practical business guidance every step of the way. And after over a decade in the entrepreneur space and becoming a mother, I'll also be sprinkling in tips for running a business and giving you a glimpse behind the scenes of what life's really like. As a gentle reminder and disclaimer, I am an attorney, but I am not your attorney. So be sure to seek legal counsel for personalized advice. Welcome to the Legal Paige Podcast. Now, before I talk about all of the legal stuff, let me just lay some background here. Jules LeBron, who is an influencer on social media, posted the OG Demure video a few weeks ago at kind of the beginning of August, and it started garnering a ton of attention. Think 48 plus million views and thousands and thousands and thousands of parodies on TikTok and other social media platforms. Now, you may be wondering, what is the meaning of, quote, very demure, very mindful? What even is that? This is hilarious because my husband even asked me this one night and just said, hey, Paige, what's this whole demure thing going on? I cracked up laughing because it had gotten to this man who is not on social media, doesn't have even a Facebook account. I think he scrolls Instagram every so often, but he's mainly like on Twitter. And I could not. I was beside myself because I could not believe that he was asking me about a social media trend that I found fascinating. I have been scrolling through tons of videos that was like very demure, very mindful, very cutesy. And so I had to kind of describe it to him. I had to do it by showing him the actual video to start off, and he was so confused. But then I said, okay, what this is it's a trend where it's kind of a spoof on being demure, but also like how you can be demure in your own life. And it's like taken on a mind of its own. So when I did some research for this episode, I went and saw that Jules had explained to various networks and news broadcasts that had her on. She explained that her version of demure isn't just about appearance, right? It's a statement of self-awareness and confidence. And demure in and of itself is kind of about being a more mindful, considerate, low-key person. And the mindfulness approach to this very demure, very mindful trend is not only are you being demure, but you're really understanding that there's a bunch of people around you in the world. You need to be mindful and considerate of those people in various scenarios that you may encounter yourself in every single day, but also really who you are and how you want to present yourself to the world. And now what was once Jules's kind of own 38-second cheeky video has evolved into this massive full-blown trend. Everyone adding their own spin on how they suggest you act demure and mindful and cutesy. Really, the only way for you to get this is to listen to and or see the actual video. So I'm going to play that clip for you here.
You see how I do my makeup for work? Very demure, very mindful. I don't come to work with a green cut crease. I don't look like a clown when I go to work. I don't do too much. I'm very mindful while I'm at work. See how I look very presentable? The way I came to the interview is the way I go to the job. A lot of you girls go to the interview looking like Marge Simpson and go to the job looking like Patty and Selma. Not demure. I'm very modest. I'm very mindful. You see my shirt? Only a little chichi out, not my chocho. Be mindful of why they hired you. Here's your reality check, diva. What's the name you'd like me to make it out to?
All right, so now you kind of get the gist on why this was a super fun trend and bandwagon to jump on over the past few weeks. A lot of trends kind of start on TikTok and then they evolve into kind of their own animal, and then they definitely go to Instagram as well. I'm going to just stop here. It's a fun trend. You can go down a rabbit hole. But really, why do I bring this trend up as your friendly lawyer? I'm sure you've either seen it or now you've already gone down a rabbit hole as we've been talking about it. Unfortunately, legally speaking, she didn't think to file a trademark application for that tagline. Not a lot of people do as they're creators online. They don't know how big something's going to get, and they honestly don't future think and project, hey, I could create, a marketing campaign off of this. I could create collateral. I could own a trademark and license this trademark to people. Then this past weekend, a man named Jefferson Bates filed for the trademark Very Demure, Very Mindful. And it left Jules feeling devastated that she, quote unquote, dropped the ball and couldn't capitalize on her own intellectual property that she truly felt like she created. It wasn't the world's now. Well, it had become other people's and the trend on social media, but it was hers to begin with. She's the original OG creator of it. And it really goes without saying, it is not demure or mindful to try and steal someone's trademark. But Mr. Bates definitely seems to be squatting on this mark without being the rightful owner and definitely fraudulently initiated this filing. He's done so in the past. Once I started looking up who this person was, I was like, oh, he's just a trademark squatter. But this is a problem. So let's talk a little bit more about this in terms of ethics, trademark registration, and priority, and the advice that I would give to Jules if I were her attorney. I want to start out with the ethical issues in this situation. These kinds of things actually happen all the time, and we see it as intellectual property lawyers. Something will become kind of famous overnight, whether it's a work of art, a phrase, a name, or someone, not the person who made it famous, will then try and trademark it, make swag out of it and sell it, buy the domain for it. There's domain squatters. And in many situations, then they try to sell the domains and the trademark application back to the original owner for like an obscene amount of money. It's truly egregious what's going on. And ethically, what's wrong with this is when you file for a trademark and you go through the United States Patent and Trademark Office, at the end of the application process, you have to certify under oath that you are the rightful owner of this, that you aren't fraudulently initiating this filing. So there's a lot of ethical issues here with somebody who is trying to trademark squat, is what I like to call it, and is really just trying to make money out of this situation. And there's not a lot of regulation on this. And I wish there was more through the USPTO. But I think we can all agree it's just icky in general, right? Because it's not just that Mr. Bates is trying to profit off of Jules' creativity. There's something really particularly underhanded about swooping in after the fact to claim ownership of something that clearly belongs to somebody else. So again, I want to reiterate here that when you apply for a trademark application, you are required to declare that you're the rightful owner of the mark. And the USPTO is a federal agency, and filing a trademark is actually a legal proceeding. So under federal law, if someone is found to have fraudulently filed a trademark application, they can be fined and or go to jail. So what Mr. Bates is doing is not only icky, but it's illegal. It's just how much is going to be enforced with this illegal activity. That has yet to be determined, so we will see what goes down with this. But let's talk about, okay, if this person filed the trademark application, now Jules either wants to file a competing trademark application or oppose this person's fraudulently filed trademark application. What does she do? I want to go over understanding trademark priority here. So in the United States, trademark ownership isn't determined by who files first, but by who uses the mark first. It's all about first in use, and they are the rightful owner. This means that Jules definitely has options to protect her mark because she was absolutely the first and can argue, and everyone has proof of online, that she was truly the very first one to use and tagline this mark. However, it doesn't mean that someone should delay filing because they know they have priority. Filing your trademark should absolutely still be a priority, and here is why. Once someone files a trademark application, you have to wait for an examiner to review it before you can take action against it. And opposing a trademark is expensive, it's time consuming, and it can take years to resolve. A little legal tea for you here. I'm not going to get into it too much because I am in litigation myself, but we are in an opposition with a trademark that we feel that we are the rightful owners to here at the legal page, and it has taken us years, and we are still not in resolution phase yet. So it's time consuming, it's very expensive, and it's actually a litigation proceeding through the Trademark Trial and Appeal Board, TTAB. Now, I don't want to go down too deep of a hole here with oppositions and what an opposition is and how it comes about. But essentially, say someone filed a trademark application and the examining attorney does their search query that they need to do online through the United States Patent and Trademark Office, through the trademark search system. They kind of look online as well and do like a general search. And maybe they see no one else that could potentially claim rightful ownership to this. They don't see any likelihood of confusion with other marks. And so what an examining attorney would do is move the application through the registration process. So I actually did talk about the steps to trademark registration in a previous episode just a few weeks ago. But this particular phase of the trademark application process is important to understand because if an examining attorney is going to approve your application, then what it does is it publishes your mark. So an examining attorney would raise no objections to your registration, or say you've been through the phases of overcoming all of the objections that an examiner has raised. So say there's a likelihood of confusion, or they want you to disclaim that you're not going to ask for a portion of the mark to be owned by you. Sometimes you have to disclaim like certain words in your mark because they're more general terms, but you're just owning the mark itself, the tagline itself. Okay, so anyway, there's obvious actions. You have to respond back and forth. I'm not going to get into that here. But what would happen, say, if you're in an opposition phase is what I'm talking about. An examining attorney is like, okay, we've overcome all objections or there are no objections. What I'm going to do is approve your mark for publication in what's called the Official Gazette. This is a weekly publication of the United States Patent and Trademark Office. This examining attorney on an application would send you a notice of publication stating the date of publication. And this is where the opposition phase would occur. So after the mark is then published in the Official Gazette, any party who believes that it would be damaged by registration of the mark has 30 days from the publication date to file either an opposition to registration or request to extend time to oppose. An opposition is similar to an actual legal proceeding in federal court, but it's held before the TTAB, which I just talked about. This is like an administrative tribunal within the USPTO. So it's kind of a way to not go to federal court. It's a way to still litigate, but it's through Trademark Trial and Appeal Board. And then this is kind of where opposition could occur with someone who may not have a trademark actually filed that the examiner couldn't find. And maybe they feel like they have some common law rights and were the first rightful owners, first in use of the mark. Although it's not required, it's always a good idea to hire legal representation to navigate that opposition process. You can do it pro se yourself. I don't recommend it. This is really where IP attorneys shine and thrive. And ultimately, what I'm trying to say here is this is why it's smarter and more cost effective to file your trademark as early as possible to avoid these situations where you might get into an opposition phase with common law right ownership over the trademark versus someone who is trying to file a fraudulent application and trying to move through the process and then ultimately license it to you or try to assign it to you for an obscene amount of money. Let's get into advice if I were Jules's attorney. If I were to represent her, I would, one, immediately file for the same mark to start the application process. This would mean that when an examiner then goes and reviews the mark, say Mr. Bates's mark, they would see not only his mark application, but they would also see her, Jules's application. And that could lead to a denial of either the earlier application based on Jules's earlier date of use and clear evidence of use. I didn't get into what Mr. Bates had filed, but he had filed an intent to use application, which is a 1B application, meaning that he's saying, I'm going to use this term some point in the future. What Jules can do is be like, no. One, she needs to get merch out right away. She needs to just start using this term in commerce and making money from this term, which she could probably already do with TikTok. This is like going down a social media rabbit hole here. Like, can you actually coin a term on TikTok? I think Jules can, because Jules has shown that she is the OG owner of this. I mean, she's been on, news broadcasts. She's been on podcasts. She's clearly profiting from this from TikTok as well because of how many views that she has. And it'd be super quick for her to be able to start some type of merch. So I would suggest she does that, and then she files what's called a 1A application, which is already in use in commerce. That way, when an examiner is looking at these competing trademark applications, they would be like, okay, you're not even using it. They would probably immediately see that this was a trademark squatter. They're not the right owner. Maybe then they initiate fraudulent filing proceedings against Mr. Bates and finally get him. I'm like, how has he not been caught yet if he's done this before? And Jules would be able to show very, very clear evidence of use in her 1A in-use commerce application. So keep in mind, though, here that the application process takes well over a year to get reviewed, let alone approved. So this is really just the first step in a waiting game. You also might be able to file the application as what's called special. I'm not going to get into that. That's totally an IP trademark lawyer thing. But this is options I would probably take or look into if I were Jules's attorney. Next, I would absolutely send a cease and desist letter to Mr. Bates, showing him the video of Jules using the mark along with her application, along with news broadcasts, and hopefully merch at that time. I would just tell her to get merch out ASAP. And then I would demand that he stop using the phrase immediately and withdraw the fraudulent application. It is absolutely likely that Bates may try to then sell Jules his actual application, something that's legal and is probably his goal all along. Like, hey, I submitted this application. If you just want to take it over, I can change ownership here. But again, I don't even think that would behoove her to do, and I wouldn't do it. I would just send the C&D and be like, stop what you're doing. I'm the rightful owner. This is very clear. Submit a bunch of evidence and proof. That's the first kind of step in this, as well as filing the trademark application. So if Bates then refuses to comply with a C&D, as an attorney, I would probably proceed with an opposition proceeding, knowing that's coming down the pipeline. Hopefully get an examiner to compare and contrast the two applications, because I would put her application in through the USPTO basically right now by tomorrow. Jules, if you're listening, please reach out to me. I can help you with this. Those are kind of the first steps that I would do. And I would love to just see this all unfold and unravel in a way that's truly going to benefit Jules, because I think she deserves the world for making this trend so amazing. And she deserves to own this trademark, this sub brand name that she's created for herself. And probably now she's like, I can make a profit. I can make a business off of this. Like, huge deal for her. And I've been following her now on social or on TikTok in particular. And I've seen just how genuinely kind and appreciative that she is of this trend going viral. It was something that she was, doing to probably, catch the eye of people, but not something that she expected to blow up this much and really completely change her life. So I think that this trend can change her life moving forward in ways that I have seen other people not be able to do on social media, particularly TikTok, because it's like you can even like create a dance and you're not going to make money necessarily off of the dance. I have never seen a phrase like this and a trend like this take off in this respect. Like NASA has done parodies off of it and spoofs. All kinds of celebrities have done it, spoofs on Saturday Night Live. Like, it has been around the world, and really around the world, not just the United States as well. So I really, really want you to profit off of your hard work in creating this trend, Jules. Let's go over some key takeaways now for the end of this episode for all of you as creatives. What am I really trying to tell you here? 1, the importance of trademarking quickly. If you go viral for a mark, or saying that you put out on social media, or you have a sub-brand mark, maybe it's not just your business. Maybe it's just a phrase that you're trying to coin and like other people are using it and you're like, man, maybe I should do something about that business-wise. Is this my intellectual property? If it is, contact a trademark attorney, or at the very least, put an application in through the USPTO and start using the superscript TM on your work. Because here's what that does. It provides people notice that you have that application in and you're meaning business here. Like, you mean business. You want to own this mark. You want to license it. You want to create merch off of it. You want to have consumers purchase things from you. You want the brand association to be Jules is the creator of the very Demure, very mindful brand. And early filing with a trademark application can prevent costly and time-consuming disputes. And really, the trademark application itself offers a clear path to enforcing your rights. So yes, you can get some common law ownership over a trademark that you've had, but she hasn't had it for that long. We're talking here like 3, maybe 4 weeks at the point that this podcast airs. So it's really important. It's like, yeah, you were first in use, but let's also be first to file if at all possible. So please remember, you need to trademark something as quickly as possible. Yes, you want to use it in commerce as quickly as possible as well. And that is what the USPTO is going to look at. But if you have not only first in use, but first to file, you're leaps and bounds ahead of anybody else that could try to get in your way for that trademark. Number 2, the role of legal representation. So navigating the trademark process without an actual IP professional can really be challenging and hard. I want you to have a good trademark team in your back pocket to aid you in getting that application in quickly, navigating these kinds of situations, going and doing their own trademark clearance, which means that they do, a full sweep and search through the USPTO, through applications and platforms that they have that search, doing general searches on social media and domain names. And then ultimately, these lawyers would provide you with clear guidance on, hey, yes, I think this is a good application to move forward. Let's go through the registration process. Or, hey, let's tweak this. Or, hey, here's some obstacles that may come up. If you're willing to deal with those obstacles, I do suggest we move forward. Or, in my professional opinion, I don't suggest we move forward. The good news is I have a firm where we trademark business brand names all of the time and taglines. It's an investment, yes, in your business that you have to hire a trademark attorney to do this and pay some filing fees, but it is one that you will not regret. I will absolutely put a link to our law firm in the show notes. That's not the legal page. The legal page is a separate legal education platform and contract shop. Griffith Swazo Law is my law firm that I work on with my legal partner and our paralegals. We help one-on-one clients there through the law firm. So I want you to definitely reach out. If you are interested in this, we can jump on a consultation call. We can kind of go through, the initial process of, hey, yeah, I think this would be a good idea. here's the steps that, we would take as legal representation for you. And then you can decide if you would like to move forward with the trademark application. Last but not least, I just want to talk about the long-term impact on your brand with trademarking. So protecting your trademark is more than just avoiding legal battles. It is about securing your brand's future. So do you want to expand your brand and sell swag attached to your brand name or a tagline? Do you want to take your brand and make other income streams? Do you want to license your tagline with another passive income stream? So all of these things are natural next steps for creatives and business owners just like you, but you got to properly protect yourself and your intellectual property and your brand mark in order to do so. So I really, really want you to consistently think, okay, if I have a logo, a tagline, my actual business name, if I have a phrase, if I just have like a little mark as well, like the Nike swoosh. If that is associated, it's all about brand association. If you want just common people to start associating all these things that I talked about with you and your business and your brand, you have to get it trademarked so people do not try and replicate you or undercut you. And honestly, a strong trademark portfolio increases the value of your business. It attracts investors and it provides massive competitive edge in the marketplace when you go to sell your business. And oftentimes people don't think about their exit strategies. And as an IP lawyer, I'm like, the more IP you have, the more goodwill associated with your brand. And the longer that intellectual property has been associated with your brand, the more value it has to your business and the higher amount you can sell your business for. So I really, really want you to ensure that your trademarks are well protected from the outset because there's just too many pitfalls down the line that I do not want you to get yourself in. Okay, so that's it. Thanks for tuning into this episode of the Legal Paige podcast. Please remember being very demure, very mindful, very cutesy isn't just about how you present yourself. It's about making sure that your business is legally protected from all angles, whether it's setting boundaries with your clients or managing your finances property or safeguarding your intellectual property through trademarks. These steps will keep your business thriving, stress-free, and make money along the way. If you found today's episode helpful, please don't forget to subscribe to the Legal Paige podcast. Go leave a review on Apple. And if you're ready to take the next step in protecting your brand, check out the show notes for more information on how my law firm, which is a sister business to the Legal Paige, Griffith Swazo Law, can help you navigate the trademark process. Until next time, stay legally legit, my friend, and keep on keeping up. Thank you so much for tuning in to today's show. Be sure to visit thelegalpage.com for contract templates, blogs, YouTube videos, and additional legal resources. If you haven't already, head over to iTunes and leave me a review and rating. It truly means so much to me to hear your feedback and inspires me to continue creating podcast content. Also, I want to personally invite you to my free Facebook group at tlpfacebook.com, where you will get access to me, my legal team, and thousands of other entrepreneurs in there for unlimited business and legal Q&A. Until next time, my friend.